Thank you for having me. I'm basically only going to reiterate what Audrey said in a much less erudite way. But I also have three broad points to make. The first is that, like Kavita pointed out, the CAA was broadly trying to reconfigure citizenship status of people. So people who were earlier secure in their citizenship of India suddenly felt that it may be reconfigured. But my argument is that in the aftermath of the riots and in the aftermath of the protests, basically all these criminal cases and the logic of the prosecution therein does exactly that. It manages to reconfigure the citizenship status of people. And it does it in three ways. First, it lays down permissible limits for participatory citizenship. So it tells you very clearly what you can do as a citizen of India and what you cannot do. And what you cannot do is the following. You cannot hold political articulations that the ruling dispensation does not approve of. Certain political positions are dangerous. You can't hold those political positions. And they're very much considered to be outside the purview of civic action. So as a citizen, you can't participate in certain political ideas and certain kinds of political thought. Two, the logic of the prosecution lays down very clearly who is a good citizen and who is an unruly subject. An unruly subject is someone who's forever questioning, who's critical of the regime, who's constantly challenging the neat narratives of development, of whatever it is. And the good citizen is someone who's reiterating it, who's coming out for the nationalist cause, and who's reiterating both discursively on social media by trolling people like Audrey, and also out into the streets, reiterating the nationalist majoritarian narrative. And third of all, what the logic of the prosecution does is it normalizes corrective action by the good citizens against the unruly subject. So it is okay for the good citizen, it is okay for the nationalist citizen to go out and either discursively or even physically correct the behavior of the unruly subject. And also the blame for such kind of retaliatory violence shifts from the good citizen who's actually indulging in such violence onto the unruly subject. The popular logic is that by indulging in these anti-national disruptive activities, you're calling it upon yourself. You're actually causing other people to retaliate violently on you. And in this regard, the logic of the prosecution now has traveled much beyond these criminal cases. It has now become the popular common sense of the Indian people. Our foreign minister was recently in Washington and he was addressing the diaspora there. And some of the diaspora are American citizens. So oddly, he first conceded that the space for debate, he called it, the space for debate in India has shrunk. And then he said that therefore those people who can't now debate in India are using international fora, the US mainstream media and such other fora, to lay out their views. And again, he confused or he misinterpreted criticism of policy for criticism of country, which is not the case. But that's how he put it. And then he invited the diaspora to intervene in corrective measures. So he said, when you see somebody doing this, come out and correct them. And that is again calling on the good citizen to correct the unruly subject, to come out and to do it discursively, to do it on social media or to do it on the streets. That is the first part of what I had to say. The second part is this, that before FIR 59 of 2020, which lays the basis of the logic of the prosecution, violence was always a crime. And in terms of protest violence, there's a very, very particular test, and that is called the spark in a powder keg. So if a situation is tense, if a situation is charged, and you go and you make a speech, that is like a spark in a powder keg, that is very directly insightful of violence, then you would be booked. Then you would be guilty of having committed an offense. But there has to be an immediate and causal link between the speech and the act of violence. That is one. The second is that any violent act conducted by an unlawful assembly is punishable in law. But again, you have to show that the assembly actually committed a violent act and you were part of an unlawful assembly. And the police has very specific powers to either disperse an unlawful assembly or to detain some members of that unlawful assembly temporarily and to charge them for misdemeanors. But the anti-CAA protests have not been framed according to these applicable laws. They have not been framed as breach of peace in the moment, an unlawful assembly damaging property or an unlawful assembly hurting someone or causing traffic inconvenience. That's not how they've been framed. They have been framed as something more spectacular, as something more conspiratorial, as something much more serious than a simple misdemeanor. And this is where FIR 59 of 2020 comes in. It was registered by a sub-inspector of the Delhi police, and he said that he has informers who have informed him that this is a deep-rooted conspiracy. And what is the conspiracy, pray? The conspiracy is, A, to embarrass the Indian government in front of President Trump, who was visiting at the time. Now, we know President Trump and concerns about self-image have resolved themselves in time, but we leave that aside for now. The second more serious charge was that there was a conspiracy to internationally further a political propaganda that minorities in India are oppressed. Now, I've never known an FIR, a first information report, to describe a political assertion as propaganda. It may or may not be, but it's not a crime. It's not an offense. So a political assertion, whether it is propaganda or not, is not an offense. But that is the beginning of FIR 59. It says that these people are indulging in political propaganda. And that is how it is framed. Now, interestingly, FIR 59 does not make any allegations about the assembly of protesters having incited violence or having been violent themselves. So the FIR is actually silent about who committed violence, where did the violence come from? And yet, the whole assembly of protesters is booked under Section 147 of the Indian Penal Code, which is rioting. So without having indulged in violence, without having been any allegation of violence, the single collective assembly of protesters is termed a rioting agent. And that is how it's seen in popular sentiment. Assembly of protesters, anti-CAA protesters, rioters. Although there's no allegation of violence anywhere, it's just an allegation that they were out on the streets, suggesting to an international audience that we are being oppressed. Now, the entire prosecution case does not answer two basic legal questions. One, who actually committed the violence? Who caused the riots? And two, was there at any point of time any causal link between the protesters and the rioters? Were the protesters the rioters or not? The prosecution does not answer these two basic questions. So the link between the arc of violence is drawn from the position that retaliation or corrective violence had to happen. You invited it. By protesting, you invited it. So therefore, the blame for the retaliatory violence is upon you. And that is the prosecution case, which is legally completely untenable. Now, on the other hand, I'll read out bits from the prosecution case in the trial of Umar Khalid's bail. The prosecution says of Umar that he conspired to provide Muslims an articulation of their grievances and a methodology for its articulation. Now, this methodology for articulation is not even violent. It's a means of protesting on the streets, but that is the prosecution's case. 2, Umar created a critical mass of Muslim protesters, communalized political space, and excited violence. Not invited violence, but excited violence from the other side, who saw Muslims getting together in an assembly and were so excited that they had to indulge in corrective or retaliatory violence. And last of all, the prosecution case says that the grievances are false, fabricated, and funded by external agencies. So it's all propaganda. And again, reading on, similarly in the case of Asif and Natasha and Devangana in their bail hearing, the prosecution's case was that they visited Muslim majority and Muslim dominated areas and campaigned as part of protests in these areas. They coordinated with imams. This is the case against them. And they organized a mob of a particular community. The prosecution repeatedly refers to Muslims or the protesters as a mob without any allegation of violence on their part. So then the assembly in itself becomes dangerous, even when it's not violent, even when there's no incitement to violence. Just the fact that they've been mobilized as a Muslim around their Muslim identity and they're protesting makes them dangerous and it makes them violent. And the last point, Section 15 of the UAPA, this is the special act that they've all been booked under. Section 15 defines a terrorist act. It says whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or sovereignty of India, etc. And this is important. Whoever does this by using bombs or dynamite or other explosive substances or lethal weapons or poisonous or noxious gases will be considered to have indulged in a terrorist act. Now, please see, it says they must have used bombs or dynamite or explosive substances or lethal weapons or poisonous or noxious gases. It's not even the prosecution case that any of this was used. But what the prosecution is suggesting is that the bare bodies of Muslim women and Muslim children and Muslim men, by being out on the street, was noxious in itself, was a lethal weapon in itself. It was a terrorist act in itself to be out on the street with the identity of being a Muslim and having mobilized as a Muslim. So what it is it is a pro-establishment political logic, but a completely untenable legal case. And the Delhi High Court, while granting bail to Asif and Devangana and Natasha in this very case, said exactly that. And I'm quoting from the Delhi High Court judgment. It said, "We are of the view that the foundations of our nation stand on much surer footing than to likely be shaken by a protest, however vicious, organized by a tribe of college students or other persons." Thank you.